based on
Thank you, Mr.
this
Barrett.
document, it says final
That's it.
verdict, guilty of fraud on government.
Thank you, Mr. Barrett.
Mentioned,
Well,
we do have to operate within these parameters.
It would seem to me to be part of a pattern of a cover-up.
That's right.
That's what it would seem to me to be. How can the Prime Minister be subject to the rule of law, like every other Canadian, if his personal department can shield him from an RCMP criminal investigation?
This Guy's Garage. Like and subscribe.
Thank you, Chair, and good morning, Commissioner. Good morning, Sergeant. Thank you for your attendance. I hope your attendance today is fulsome, that we get through the full committee without receiving a notice of motion to adjourn. At the heart of the SNC-Lavalin scandal, there were a number of players within the PMO, the PCO, and the Ministry of Finance. However, the principal person of interest in the SNC scandal was at all material times the Prime Minister, Justin Trudeau. To you, Commissioner, the scandal is now over 5 years old. When did the RCMP interview Justin Trudeau?
I'll let Mr. Pain-Saints further discuss about the interviews, but it is 5 years old, and the matter was brought to our attention in 2019 and officially concluded in January 2023, in which we notified Madame Wilson-Raybould as well as Mr. Scheer, who had written a letter to the Commissioner Lucky at the time.
Thank you, Commissioner. The question was very specific. How many times in the last 5 years did you interview Justin Trudeau?
He was not interviewed, sir, or Mr. President.
Okay, and why not?
I'll ask Mr. Pain-Saints, who was leading the investigation, to add a little bit.
Yes, thank you, Mr. Chair. So, in relation to this, what the RCMP conducted as far as for the objective for the review of the matter, what we've done is we've proceeded with a phased approach, which initially we looked at the potential witnesses that could provide some information as far as to precision for the elements of the offense. So we proceeded in this phased approach. As we proceeded, we determined if there was any further investigative steps that were warranted given the circumstances of the case.
My time is very limited. Why did you not interview the primary person of interest? At the heart of this investigation was Justin Trudeau's political interference for his own personal gain and the gain of SNC-Lavalin. I can inform both of you gentlemen that in my over 30 years of experience as a defense counsel and as a Crown attorney, I have never heard of any investigation where there wasn't any attempt, whether they agreed to interview or not, any attempt to interview the person of interest. Was there at least an attempt to interview Justin Trudeau, yes or no?
No.
Did the RCMP obtain all relevant documents to further the investigation, including access to cabinet confidential information, simply seeking a yes or no response?
We were limited with the information that we had access to.
Was that a yes or a no, sir?
I don't know. We didn't know. We don't know. We still don't know to this day all the information that's out there because some was protected.
I'll take that as a no. Despite collecting reams of evidence, including evidence from the Ethics Commissioner and testimony from Jody Wilson-Raybould at committee, why didn't the RCMP exercise its absolute statutory right under the Criminal Code of Canada to obtain a production order and or search warrant from a justice to obtain those cabinet documents?
We weren't able to acquire or obtain enough information or evidence that would warrant us to obtain a production order.
RCMP spokesperson Christy Veenstra is on record stating that to obtain a search warrant or production order, there must be reasonable grounds to believe that a criminal offense has been committed. The evidence at hand is sufficient to convince a trier of fact. The evidence at hand is insufficient to convince a trier of fact of the alleged offense. Clearly, she is conflating the legal threshold of policing with the Crown Prosecution Service. Both of you, sirs, will agree that your sole responsibility is to determine whether there are reasonable and probable grounds to lay a charge. It is not your mandate to prove the charge beyond a reasonable doubt, which is the Independent Prosecution Service. Would you agree with that?
I agree, Mr. Chair.
Thank you. Was obstruction of justice involving Justin Trudeau the only offense you were contemplating in this regard?
No, there's also intimidation of a justice participant.
Thank you. You would agree that the charge of obstruction is a straight indictable offense, meaning there is no limitation period, punishable by 10 years in prison, a very serious offense. You'd agree, sirs, that there is nothing precluding your service from reopening the investigation against Justin Trudeau should new evidence become available, including a release of cabinet confidential information.
I would say, Mr. Chair, with any investigation, when there's new information that arises, yes, we have a look at the investigation itself.
To quell public concern, Justin Trudeau, despite his office, is subject to the full impact and consequences of the Criminal Code of Canada. He is not above the law, correct?
I do believe I said that last time I was in front of the committee. No one's above the law.
In my experience, sirs, homicides have been investigated and prosecuted in lesser time than your service has invested in investigating Justin Trudeau. Is there an overall general reluctance in charging a sitting Prime Minister, yes or no?
I would say to that, Mr. Chair, is that we follow the evidence, and if the evidence warrants charges, we charge.
So there's no general reluctance in charging a sitting Prime Minister. Is that correct?
If the appropriate evidence is available.
Thank you. You would agree that the purpose behind the offense of obstruction of justice is to maintain the integrity of the justice system and upholding the rule of law, that all the principles that were articulated in Jody Wilson-Raybould's testimony in warding off Justin Trudeau's relentless campaign of pressure and intimidation. You'll agree with me, Commissioner, the evidence is clear. This is not a one-off. Over the course of 4 months...
Sorry, Mr. Brock, but we're over time here.
My understanding is that, there was a look by the ethics commissioner at this, and I want to make clear something, and perhaps you could also characterize that. When you breach the ethics code, and politicians have frequently breached this ethics code, it doesn't mean you're necessarily committing a criminal act, correct?
That's correct.
And could you sort of explain to us the difference between committing a criminal act versus a breach of the ethics code?
Well, if you look at the threshold for a criminal act, you need the right evidence to get the legal documents to allow you to do production order or a search warrant to eventually lay the charges, if there are charges to be laid.
Ms. Wilson-Raybould was asked this very question, if a criminal act had been committed, and it was her view that a criminal act had not been committed, correct?
She stated that it was inappropriate, she felt it was inappropriate behavior, but not criminal.
Thank you.
One of the frustrations that I have, and I know that the Honourable Ms. Wilson-Raybould also suggested this, that in her role, she was both the client and solicitor. And in fact, that is one of the challenges that we have, where we have a government that consistently, this is my opinion, by the way, I'm not putting this onto you, claims both the client and the solicitor privilege on all matters, claims confidence on all, or cabinet confidence on all matters. So when dealing with a scenario where the institution under investigation is, by virtue of its institution, both the client and the solicitor, how do you navigate getting any kind of information from them?
Those are the parameters we deal with. The team itself had requested additional information, and it was refused. And like I said, those are the parameters we operate in. I could say there's something similar when we navigate in national security space with information that we can use and can't use.
And it's still your assertion that applying for a court search warrant for the Trudeau cabinet documents and records of communication, that you didn't have sufficient evidence to even begin that?
We didn't have sufficient information even to entertain to go to production order or even a search warrant.
So then why did you wait almost 2 years to end your examination of the situation without having the ability to do a full investigation?
So there's a couple things there where the sensitive international investigation wrapped everything up in spring 2021. And there was a change in management at several levels, and that's on us, and we looked into it, we corrected that. There's probably 10 months there that it could have been done in a shorter time. It's just a change in management, and the reporting made it that we informed Madame Wilson-Raybould in January 2023, and subsequently Mr. Scheer by way of a letter.
And where would you have been in that decision-making matrix?
I was Deputy Commissioner of Federal Policing, so there would be a program manager reporting to me, and then the team would be reporting into 3 different levels before getting to me.
Okay, so you would have been involved in making the delay decision?
It's not a delayed decision. It's just it was the change of resources within the organization made it that when it got to me, I presented to the commissioner and then forwarded.
Certainly, you can appreciate that on the outside, having had 2 elections within a period where this was highly contentious, the timing for the general public, I think, leads to, whether necessarily so or unnecessarily so, theories of cover-up, theories of delay, theories of political interference and timing, because, again, to the same effects that you don't have access to information, it's my assertion that when the public doesn't have access to good information, they're led down these paths. So was it also you who would have ultimately made the decision on whether to prosecute or not?
Ultimately, I rely on the subject matter experts from the union, from the unit. But I just want to go back to the question, not the question, but the comment, Mr. Chair, is that at no time did we brief the minister or the PM or any political appointed individual on this file. So to even suggest that this was delayed, they didn't even know at what stage we're at with the investigation, delayed because of elections. It was on us. I admit there's a mistake on us that it could have moved forward, and we corrected that.
And so back to my question, would you ultimately have been the person to decide whether to prosecute or not prosecute?
I would sit down. Ultimately, we would have a discussion with the Crown prosecutor assigned to the file and have a discussion. But within the team here, I'd be sitting down with our folks and being guided by our subject matter experts.
Okay. Just to be clear, you're the commissioner now.
I'm the commissioner now.
Okay. And I'm just asking you to take some leadership now. Ultimately, on your end, would the decision have been yours, or would you have reported to somebody else to make the decision?
It would be. I wouldn't delegate it down, but every charge doesn't come up to me for approval.
But certainly one involving the Prime Minister would likely have your approval.
I would be informed and I'd be supportive, but it's not every charge that makes its way up to the Commissioner.
But certainly, I think, look, let's just be frank. You have a duty of candor. I'm going to extend that duty to this committee. I need you to be candid and take responsibility if you were the one to make the decision, or if you would have reported up to somebody to make the decision. Ultimately, there would have been somebody sign off at some point in time. It's not if there's a chain of command in our paramilitary policing units, there's a chain of command that you would have been a part of. Did you make the decision, yes or no?
I would have been guided by my subject matter experts and supporting that. So obviously, if we're charging the Prime Minister, for sure, you'd be on board.
Thank you. I did give you a little bit of Mr. Housefather's time because he was short.
I have questions for you that come from an access to information request. It's ATIP A-2021-02029. It deals with a decision tree from Section 121(1)(c) of the Criminal Code, fraud on government. I provided both you, Commissioner, and the Staff Sergeant with this just before the meeting started, just as we moved through the document. So in this decision tree, it asks a series of questions. The first question, was Mr. Trudeau a government official at the time that he took a vacation to Bell's Cay?
Go ahead on the point of order, Ms. Khalid.
I realize that the witnesses have documents and Mr. Barrett has, but we would like to also follow along, if that's okay, if Mr. Barrett can share them.
Okay, the challenge
on that point of order?
On the point, Mr. Barrett.
Yeah, I'd be happy to provide them to the clerk. They'll go into translation, and then they'll be furnished to other members of the committee. It wasn't proactively disclosed by the government. It was made available by ATIP. But I don't have any questions for other members of the committee, so they don't need a copy of it. If they would like to email me and ask for an English-only copy, I can furnish them with that, but I don't have it in French. I will provide it to the clerk. Translation services can deal with it, but I'd like to continue with my questions, Chair. It's not required for me to provide other members of the committee with documents that are provided to witnesses. It's not in the standing orders.
So I'm going to ask that Mr. Barrett furnish that to the clerk so that we can have it translated and supplied. If he's only referencing it for the purposes of asking questions, I don't see, it's not a document that's submitted to the committee for that purpose. He's referring to.
Okay, so I mean, if that's the case, if the witnesses have it and Mr. Barrett has it, we as members of the committee should be able to look at it too while these questions are going on. I'm not sure if my colleagues agree, but I'm a little bit lost without having this document in front of me, so I can follow along too.
So I'm going to allow this to occur. Mr. Barrett will be referring to the documents, I assume, you mean, based on your first question.
I'd like to finish my first question, yes.
Right. You're going to complete your first question. But the point I'm making, Ms. Khalid, is that he can reference, just as any other member has paper in front of them that's not shared with other members of the committee. This is an access to information document that he has in his possession. He'll be reading from that document, I assume, and that will be translated at a time. So I don't really see the need for other members of the committee to have that. Yeah.
Thanks, Chair. The difference is that we don't share our questions or our comments with witnesses prior to us asking them. And in this instance, those documents have been shared with the witnesses. So I don't know if my colleagues want to jump in here.
I'm going to go to Mr. Barrett first and then Mr. Green on the point of order.
Sure, Chair. It was provided to the witnesses at the start of the committee meeting. It's an RCMP document. They provided it in the ATIP. But if it makes other members of the committee uncomfortable that the RCMP are able to follow along, then I would just kindly ask for the clerk to collect the document from the witnesses, and I'll continue with my questions.
Okay, so just received clarification. We cannot distribute those documents because, from what I understand, they are in one language. But if Mr. Barrett wants to distribute that to other members of the committee in that one language, then you can have that document in front of you if that's what the preference is on your side or any other side. So, no. Mr. Villemure says no. So can we collect the documents from the witnesses then, Mr. Barrett, and then... Sorry. You are? Yeah. Thank you.
Yeah, if the Liberals don't want the RCMP to see the decision tree...
I'm so sorry, Chair. I can't allow those kind of statements.
If the Liberals... If I have the floor, I have the floor, and I have the floor. And I still... If the Liberals do not want the witnesses to have the documents, then I'll leave it to the chair to instruct the clerk to collect them, but I'd like to finish my questions.
Okay, so I'm going to instruct the clerk to collect the documents.
Mr. Chair, respectfully, before you make decisions
on the same point of order, I
order,
apologize. Go ahead.
Respecting the standing orders, I'm duly accorded the time. I would suggest, just so that we're not setting a dangerous precedent in terms of what expectations are, I would suggest that each of us have, through our own offices, the ability to do research, to do preparation for committee. And while it might be a courtesy that could be extended from time to time, I would just go on the record to state I surely would have no expectations of any party, both government, opposition side, to provide me with their homework in advance. I'll just state that. Mm-hmm. So I'm a bit uncomfortable that we're going to start to put constraints on. And I'm saying this objectively because it could happen to any one of us down the line. If we've done the work and we've gone through ATIPs and done all the stuff, as New Democrats, we don't necessarily have the resources to have big research policy bureaus, so we're doing it on our own with our incredible team behind me here. I just want to make sure that we're recognizing this would be a courtesy and not some kind of precedent in this committee where we're going to start having to share our homework, because I have no interest in that. Thank you.
Yeah, and I appreciate that, Mr. Green. And I guess if we want to broaden that a little bit, the challenge runs with the risk is that, there are other articles. This is an ATIP article, but there are Globe and Mail articles. There are CBC articles that people refer to all the time, but that are used in the line of questioning. So, Mr. Brock, I saw your hand up on the same point of order. Before I make a decision on where we're going to go, I think I've already made the decision, but go ahead, Mr. Brock.
Very quickly, what my friend Mr. Barrett was referencing comes out of the David Watts Manual of Jury Instructions. Any member can Google that manual and find that tree that Mr. Barrett is referring to.
So, I'm going to ask the clerk, Mr. Duhaime. Mr. Barrett is going to reference to the document in question. I'm going to ask the clerk to collect the document if that's okay. And then, Mr. Barrett, if you want to continue on your line of questioning, I think you'll give the commissioner and Mr. Pinsence a pretty good indication of what's on the document. So I'm going to ask you to go ahead. I've stopped your time. You've got 4 minutes.
Sorry, Chair. I don't need the witnesses to give their documents back. It's absolutely fine, but I did want to raise this as a point because when we are giving documents to witnesses, we should be very mindful as to how those documents are circulated to the rest of the committee. In this,
Holy Hannah.
in this instance, I'm fine if they can reference those documents at this time.
Okay, so I thought the original intent of your interjection was to not have those documents in the hands of the witnesses, so go ahead.
My original interjection, Chair, was that we can't see the documents that the witnesses and Mr. Barrett were referring to.
Okay.
Having listened to the comments of my
Perfect.
colleagues, I'm okay with it this time, but I'm hoping that this does not become a common occurrence.
Okay, thank you. Keep the documents, Mr. Duhaime, Mr. Pinsance. Mr. Barrett is going to reference those documents. Mr. Barrett, 4 minutes and 17 seconds. I'm starting your clock now. Go ahead.
Yeah, I don't need the approval of Liberal members for the material that I'm going to ask questions on. This one's very straightforward. It's a decision tree on Section 121(1)(c) of the Criminal Code, fraud on government. It's by the RCMP, and they've populated information on the document. It asks a series of questions with respect to Justin Trudeau's visit to the Aga Khan Island, Bells Cay. Was Mr. Trudeau a government official at the time? And it says yes. Did Mr. Trudeau accept a benefit from the Aga Khan? It says yes. Did the Aga Khan have dealings with the government? It says yes. Then it says, did Mr. Trudeau have consent in writing of the head of a branch of government for whom he worked? It says unknown. At that point it says, if yes, then the final verdict would be not guilty. But it goes on, if no, did Mr. Trudeau know that he accepted was a benefit from a person who had dealings with the government? Yes. And then if yes, it says, final verdict, guilty of fraud on the government. Now, we know that, in fact, Mr. Trudeau did not have a writing from the head of branch of the government for whom he worked, because that question was put to him in the House of Commons. He was asked, in the House, it was asked, did the Prime Minister give himself permission to take that free holiday in 2016, to which Justin Trudeau replied, Mr. Speaker, no. He was asked again on April 26, 2022. Again, the answer was no. So Conservatives put the question to the Prime Minister to answer the only open question on whether or not the RCMP should lay a charge of fraud on government against Prime Minister Justin Trudeau in the case of his illegal vacation to Bells Cay. Now, illegal it was certainly law-breaking in that it broke the Conflict of Interest Act. The question is, did it break Section 121(1)(c) of the Criminal Code? Commissioner, did the RCMP call Mr. Trudeau and ask him the question?
I would have to ask Mr. Pinsance because I wasn't getting ready for the Aga Khan file, and I'm not as familiar with the Aga Khan file as we are with the Jody Wilson-Raybould.
Staff Sergeant?
Yes, so, Mr. Chair, so all I should have to point in relation to this specific decision tree is, of course, this is one part of a multiple pages document, so of course this is only an excise part of this. And now to answer the question as far as did we contact the Prime Minister in relation to this one? No.
Okay, so he wasn't asked, and it was left in the document as unknown, and the only open question on whether or not it met the standard of fraud on government. I want to refer to that same ATIP, and a Sergeant Arbor, who was the team lead for SII Team 3, said, quote, if further information of evidentiary value is to be received, SII will review and determine the appropriate course of action.
Go ahead, Mr. Sabera.
Thank you, Chair. Just in terms of MP Barrett's commentary right now, is this pertaining to the actual subject matter we're studying today or not? I'm just going to go to relevance.
I know you've been on this committee for a couple of times. 17 months I've been on this committee as chair, and in every circumstance I allow members to utilize their time in the manner in which they want to. And I expect that Mr. Barrett's going to bring it back, as I expect every other member will do the same thing. So, Mr. Barrett, I really, on the issue of relevance, I've dealt with this many, many times, okay? I don't want to hear another issue of relevance if we can. If we can avoid that to save time, I would appreciate that, okay? Mr. Barrett, go ahead, minute and 21 seconds.
Yeah, it's part of a pattern, Chair, from the Liberals, Ms. Khalid, Mr. Sorbera, to interrupt the line of questioning to try and cover up for the Prime Minister, and she's going to do it again right now. On the key question of if Justin Trudeau had consent to engage in the activity, the only question was if Prime Minister Justin Trudeau committed fraud on government. The RCMP didn't pick up the phone. But Conservatives asked him the question, we got the answer. And that answer is publicly available, and it was not protected like transcripts from a committee. So it could be used and has evidentiary value. Knowing that, and knowing based on that decision tree, wouldn't that affect the decision of the RCMP to lay a charge of fraud on government against the Prime Minister if all of the criteria set out in the decision tree from Watt's Manual of Criminal Jury Instruction were satisfied? Wouldn't that new evidence satisfy your investigation?
Again, Mr. Chair, I'm not in a position to say all the evidence that we had or we didn't have. It would warrant a follow-up on that file and come back to this committee explaining what we had on the file and the reasons why we didn't lay any charges. But I'm not in a position right now to say what evidence we had that came to the point that we didn't lay any charges.
Well, with due respect, Commissioner, the only outstanding question on the decision tree provided in the ATIP was whether or not the Prime Minister had consent. It was the RCMP said it was unknown. We satisfied an answer to that question and that he did not. And based on this document, it says final verdict, guilty of fraud on government.
Thank you.
Of the key witnesses, did you directly interview Honorable Jody Wilson-Raybould?
Yes, we did, Mr. Chair.
And in the course of your questioning, was Jody Wilson-Raybould able to provide you with all the information that you were asking of her in those interviews?
Again, we had to follow the parameters of the waiver and authorization that we obtained.
So in other words, is it safe to say that in that interview with the former AG and Minister of Justice, she would be unable to disclose information pertinent to the foundation of an investigation for potential charges or perhaps documents that would be ordered through, attained to the courts?
That's correct, Mr. Chair.
And so it's logical to say that when the Honorable Jody Wilson-Raybould states, based on what the parameters of the OIC, that there isn't grounds for criminality, it's within those tight parameters from which you would have also drawn the same conclusions.
We came with these conclusions based on the parameters for which we operated.
Was there a frustration in not being able to actually get to the heart of the matter?
I would not call it a frustration, Mr. Chair, but of course we always endeavor to obtain as much information as possible so that the information is as complete as possible.
Was there an opinion in that interview that if Honorable Jody Wilson-Raybould was able to say more, she could have said more if those parameters weren't put on it?
Again, Mr. Chair, I would not be in a position to speculate as far as what information could have been provided and if that information would have led to the establishment of the elements of the offense.
Was there anything within that interview that would have given you any kind of credence for requesting an expansion on the OIC to allow you for greater access to personal testimony and documentation?
So to this question, Mr. Chair, I would have to say that of course, we sought an expansion to the original order in council.
And it was denied?
And this, of course, we made the request, and we obtained a waiver and authorization, which were the same parameters as the one in order in council 2019-0105.
So you made a request for an expansion, it was approved, and they gave you the exact same information of the original OIC?
What I should specify, Mr. Chair, is that we did receive a waiver and authorization, not to the parameters that were requested.
Correct.
But we did receive one. So
which was the same as the original.
Thank you, Mr. Green.
I share your frustration. Thank you.
Okay, thank you.
You were interrupted last time because the Liberals didn't want us to shed a light on why the criminal investigation had been stopped on SNC-Lavalin, and they're continuing to do that. It seems clear that the RCMP didn't put in as much effort as the Ethics Commissioner into their investigation. The Ethics Commissioner stated that Justin Trudeau violated Section 9, and you didn't do as much. Mr. Chair, the Ethics Commissioner's parameters and criminal investigation parameters are completely different. I'm going to ask another question. How many hours did you spend on the investigation? I'll ask Mr. Pincès to respond. Mr. Chair, I don't have that information. We're talking about a considerable amount of time. You don't have an answer. How many investigators were allocated? I don't know the exact number, but about 10, under 10. How many people were investigated? We spoke to 4 witnesses, and there were 5 interviews, 4 witnesses. And so you were aware of the list of people who were questioned by the ethics commissioner. I just have a few questions. The ethics commissioner spoke with Ben Chin, Adarmekaz from the Prime Minister's office, Michael Warnick from the Privy Council, Bill Morneau, Finance Minister, Justin Tu from the Finance Department, Katie Telford, Gerald Butts, Neil Bruce of SNC-Lavalin, and Justin Trudeau. Did you interview any of these people? No, we did not, with the list that you had. And so how can you say that you spent as much time and as much energy as the ethics commissioner on your investigation to determine that no charges were to be laid if you did not take the time to validate the information? My response in this case, Mr. Chair, is that we followed parameters in interviewing witnesses. We were looking at witnesses who could give us information, if you would allow me, that would allow us to determine the offense. Mr. Pincès, did you request access to any kind of documents? We received documents from certain witnesses. Were you refused documents during your investigation? Some documents we were not able to examine considering the parameters. Did people say to you, no, you can't have access to this information for your investigation? Yes, for the parameters. Who refused to give you information? It was a witness, the Chief of Staff, pardon me for using the English terminology, for Miss Wilson-Raybould and Miss Prince. And so they refused to give you information. Shouldn't refuse. I believe that the information was outside of the scope of what was authorized. You talked about fraud and the intention to commit fraud. How could you then conclude that the Prime Minister did not have the intention of committing a crime if you did not even take the time to ask the question to the Prime Minister? In this case, when we're talking about RCMP interviews, we reviewed all of the information in different testimonies, whether it be the ethics commissioner or other sources. The strategy was to establish the facts that an offense had been committed.
A part of the RCMP's examination to determine whether the Prime Minister violated Section 139, Sub 2 of Criminal Code by committing obstruction of justice, correct? That was part of the RCMP's examination.
That's correct, Mr. Chair.
And paragraph 19 of the RCMP investigation report states that the strongest theory towards an offense of obstruction of justice was that the Prime Minister shuffled Jody Wilson-Raybould out of the position of Attorney General so that a new Attorney General would make a different decision regarding the prosecution of SNC-Lavalin, correct?
That's correct, Mr. Chair.
And it's fair to say that the RCMP did not have access to all material evidence surrounding Ms. Wilson-Raybould being shuffled out as Attorney General, correct?
That's correct, Mr. Chair.
And so, just to clarify then or emphasize, the RCMP did not have access to all material evidence on the strongest theory surrounding the Prime Minister's potential criminality involving obstruction of justice, correct?
That's correct, Mr. Chair.
And the reason the RCMP did not have access to that material evidence on what was central to determining whether the Prime Minister broke the law was because of the parameters of the scope of the Order of Council with respect to the waiver of cabinet confidentiality, correct?
That's correct, Mr. Chair. The parameters did not allow us to fully look into this one. However, I should just add...
Thank you for that. You answered it. The parameters did not allow you to get that evidence. Now, there is one person who had the authority to expand the parameters of that order in council, and that is the Prime Minister himself, correct?
I would have to say, Mr. Chair, I'm not exactly sure of the exact process of where the Prime Minister would be involved in such a decision. However, I do believe the decision has to be made within the somewhere within the government.
I would submit the decision would have to be made by the Prime Minister, but the RCMP went and requested an expansion of the scope to obtain that evidence, to follow that evidence, correct?
Before we proceeded with the assessment, yes, we did make a request for an expansion to the parameters.
I would just add, Mr. Cooper, it was not to follow the evidence, it's to glean additional information. That could be evidence.
Correct. And that request was turned down on August 30th, 2019.
I would have to say, Mr. Chair, that the request for the expansion was not allowed.
It was turned down, and it was turned down by the PCO, the Prime Minister's Department, correct?
Mr. Chair, we did receive a letter from the Department of Justice. I could not remember exactly, specifically, if this came from the...
Well, it was from the PCO, and that's in the RCMP's investigation report. And would it be fair to say that the refusal by the Prime Minister's personal department, the PCO, to expand the scope of the Order in Council significantly impeded the full investigation into the Prime Minister's potential obstruction of justice?
It limited our capability of pursuing a full investigation.
And it would have limited it in a fairly significant way. Because after all, we're talking about going to the heart of the matter of obstruction.
And again, I don't know what additional, not knowing what additional information is out there, it's hard for me to speculate that there's a Pandora box out there which is full of information, so it's hard for us without speculating.
Well, let the record show that the Prime Minister's Department, the PCO, obstructed the RCMP investigation into the Prime Minister's potential obstruction of justice. Are you aware of any other Canadian who can single-handedly block the RCMP from investigating his own criminality in such an effective way as the Prime Minister?
Good question.
Fantastic. I wouldn't use the term, Mr. President, I wouldn't use the term block. The RCMP is, when it runs an investigation, it operates within the parameters and the regulations that we're allowed to. And we see international security investigation as well, where there's some information that we don't have access to, we can't use into an investigation. So it's the parameters. It's the parameters that we are.
I think the answer to that question is there is no one who has such powers. And was any explanation provided by the Prime Minister's personal department why there was this refusal to expand the scope of the Order in Council?
Again, Mr. Chair, as far as for a response on this one, of course, it was indicated, of course, the importance, of course, of these privileges that do exist. They are there for a reason, and again, as the Commissioner mentioned, we do have to operate within these parameters.
It would seem to me to be part of a pattern of a cover-up.
That's right.
That's what it would seem to me to be. How can the Prime Minister be subject to the rule of law, like every other Canadian, if his personal department can shield him from an RCMP criminal investigation?
Absolutely. So, Mr. Chair, I'll let individuals draw their own conclusion. What I come back to is we operate within a set of regulations and parameters that, unfortunately, we made the effort to go and get additional information, and it was refused.
Pursuant to the ATIP received by Democracy Watch, I understand that literally within hours of Jody Wilson-Raybould's testimony at the Justice Committee, you were engaging in discussions with a local Crown attorney. Is that correct?
I would have said, Mr. Chair, following the review of the testimony, yes, there was some consultation.
There was a telephone call. There was actually a meeting with the Crown attorney the very next day. Is that your recollection?
It was shortly after. Sorry, Mr. Chair, I cannot remember exactly the day, but shortly after, yes, that's correct.
Did you get any sense from the Crown attorney during those initial discussions, those initial days, that there was a reluctance from the Crown Prosecution Service not to give you advice with respect to charging Justin Trudeau?
I would not go into the full detail of what discussion took place between us and the Crown in this regard, as far as for this. But yes, there was some discussion that took place shortly after. That's correct.
We know that every charge under the criminal code carries with it two elements: the actus reus, the mens rea. The act itself, the intent, correct?
That's correct.
And are you familiar with the leading authority on obstruction of justice, Regina versus Beaudre from the Supreme Court of Canada?
I would say right now, I wouldn't know the full details, Mr. Chair.
I'm going to read out a couple of components. The actus reus of the offense of obstructing justice is that the act has the tendency to defeat or obstruct the course of justice. The mens rea is a specific, deliberate intent to do the act which will result in an obstruction of justice. Success is not necessary. The offense is made out even if the accused fails to succeed or fails to complete the attempt to commit the offense. Pursuant to another decision, Regina versus Watson from the Ontario Superior Court, it is no defense that the actions were an error in judgment or a mistake. With the evidence that you did receive, which largely consisted of the Ethics Committee report, the testimony of Jody Wilson-Raybould, was there an impediment of the actus reus or the mens rea to obstruction of justice?
I would have to say, Mr. Chair, when we conducted the review, I would have to say the mens rea portion of it was part of the main focus of our review.
Thank you. I left off in my first round, which was essentially talking about the evidence that we heard from Jody Wilson-Raybould, that this wasn't a one-off, that over the course of 4 months, no fewer than 11 different officials from the Prime Minister and down in a series of meetings, memos, and telephone conversations attempted by means of varying degrees of subtlety to change the AG's mind. Explicit political considerations were raised, the impact of SNC-Lavalin's conviction, job loss, and company relocation, which was later proved to be a lie, and upcoming elections, both provincially and federal. This at all times was Justin Trudeau's problems. We also have recorded evidence, not just a he said, she said, recorded evidence between Jody Wilson-Raybould and the Clerk of the Privy Council. I'm quoting here from Michael Warnock. The Prime Minister is quite determined, quite firm on this. He said that 4 times. Wants to know why the DPA route is not being used. He's going to find a way to get it done one way or another. He's in that kind of mood. This is really important to him. If that doesn't cry out for a specific intent, I don't know what does. What do you say about that?
What I have to say, Mr. Chair, is when we looked at this specific, and of course I'm referring to the quotes that were just mentioned here, but of course in the assessment, we did assess these comments were made. But again, we had to take a more global approach when we looked at all the comments that were made. So of course, our determination vis-a-vis the mens rea portion is based not only on some of the comments, but on the totality of the evidence, the totality of the statements that were made.
And the totality is the Prime Minister made this his personal mission to interfere in the criminal prosecution for his own political needs and the needs of SNC-Lavalin. Do you agree or disagree with that statement?
Mr. Chair, I would say that the assessment that we've conducted again, our conclusions were that there was insufficient evidence to substantiate an offense.
Do you understand why Canadians feel there's a two-level tier justice here in Canada, that the Prime Minister is immune from prosecution because he can hide behind cabinet confidences, he can commit a litany of criminal offenses and just say, sorry, cabinet confidence, I'm not going to allow the RCMP to investigate. Do you understand their concerns, sir? Do you understand Canadians' concerns?
If you quick response, please.
Yes, Mr. Chair. As far as for this, and we're talking about like ethics and criminality here, which sometimes seems to be intertwined. But again, as I indicated earlier, we have to follow the parameters as laid out in the criminal code.
There's been a lot of allegations. Again, can we confirm again that the Prime Minister was not necessarily the one person of interest in this investigation?
No, I think when you look at the report, there's people from PMO's office, there's people from the Justice Department, and others that were interviewed.
An official inquiry of Ministry number Q1649 concerning communications and pressure by government on the SNC-Lavalin affair concerning the date June 19th, 2023 revealed a call from a Trudeau minister who was not then the public safety minister, but he is now, and the RCMP described the call as, quote, seeking to speak to the deputy before question period regarding a media story about an RCMP investigation that was ATIP'd, end quote. So do all ministers have a hotline to the Deputy of Specialized Policing Services for updates on criminal investigations into their government?
I'm not aware of the incident that you're referring to. And as I said, this is the Deputy of Special Police Services. I'm not aware of that call, and like I said, I brief up.
Okay.
And sometimes there might be clarity if there's an article in the media that comes out with regards to one investigation. Sometimes the minister will reach out for asking clarity.
Sure. Not the Minister of Public Safety reaching out seems highly suspicious. I don't have the number for the Deputy of Specialized Policing Services, and I don't think they'd be interested in taking my call. And so I wonder why the Prime Minister's fixer and childhood babysitter is able to get that kind of access. Are you investigating any contractors or subcontractors who worked on the ArriveCan app?
So we did receive a complaint referring to inappropriate contract or inappropriate
allegations of misconduct.
And with that, and that was not related to ArriveCan, and now with the ArriveCan, we've blended them both into one investigation.
So you're investigating ArriveCan?
Yeah. Well, not ArriveCan itself. We're investigating the totality.
The totality.
Yeah.
Okay. Last week at committee, government officials said they're sufficiently suspicious of wrongdoing in the case, and they're gathering documents. So the RCMP is doing the same, is sufficiently suspicious and is investigating. I just need to be clear on this.
Well, Fred?
Sorry, Mr. Chair, just to be clear, which investigation are we talking about?
I'd love a list, but specifically ArriveCan.
So on the matter of the ArriveCan, of course, we did receive information on it. We are reviewing the Auditor General's report, and of course, we'll take action as required.
So the AG said that a production order would be needed to get her full files. Have you received? Are you in receipt of all of the AG's files on ArriveCan?
Again, I would. As far as for the information that the Auditor General has mentioned, as far as for the RCMP requiring a form of judicial authorization to obtain the documentation, of course, this is a step that we'll need to assess to determine.
Have you taken that step? Have you requested the information? Have you undertook that process?
I would have to say, Mr. Chair, right now, because we're in the process of obtaining that information, I would reluctant into speaking to whatever steps the RCMP is taking in relation to this matter or any other matters.
Okay, so you're not able to say because it's an ongoing, it's a developing situation.
Again, Mr. Chair, I would have to say that, yes, we process in each of these cases, we process step by step. We conduct the same level of assessment, and we determine, again, our goal is not to replace the role of the Auditor General or any other bodies.
Sure.
Our role is really to focus on criminal activities, and that's exactly what we're
course.
doing in this or other cases.
You know, the procurement ombudsman reported that 70% of resources were bait and switched in the ArriveCAN contracting. We heard testimony of Christian Firth from GC Strategies forging documents, specifically resumes, in order to win government bids. These are very serious things. We've heard this now in the reports of independent officers of Parliament. Allegations of fraud, forgery, threats, intimidation, destruction of evidence, bribery, and extortion. All of these things have been brought to light in this ArriveCAN scandal, and so the question of what's in the public interest, and we've heard today concerns about Canadians having confidence in their institutions. And, with my questions about the Aga Khan issue, it seemed like it stopped short of investigating up to the Prime Minister. With the SNC-Lavalin scandal, it stopped short of investigating the Prime Minister. And my questions today are just to make sure that we're not stopping short of getting all the answers that Canadians need. And I'm just wondering if you have anything more to say on with the totality of what you've heard on the Arrive scam. Is there an investigation?
So Mr. Chair, and I confirm that there is an investigation, and we're not going to comment because it's ongoing.
I've seen allegations of the RCMP being at the beck and call of Prime Minister Justin Trudeau. Is that true?
Like I said, I haven't briefed the Prime Minister on maybe on a couple files since I've been in a senior position, but we're not. It's not the RCMP is not politically driven. We're independent. The fact is that the leader of the opposition can write a letter to ask for an investigation. That we're doing it demonstrate that we're not politically driven.
And so what I want to offer you today is the opportunity just to reflect on the fact that, as you've testified, the Commissioner had access to more information that you had. I think that that's a hard thing, I'll just put on the record, for Canadians to be able to digest, to look at it, for journalists to be able to digest the fact that the Commissioner has more access than the RCMP on this matter. And so you may or may not recall, but it was our part of the NDP who had called for the federal government to launch a public inquiry. And I know that there's lots of conversations around the cost of inquiries and the powers, and certainly we've come off the Rouleau Commission with the Emergencies Act, and there's lots of people with opinions on that. But would you, kind of having experienced what you've experienced and what you've contemplated here today, would you agree that an inquiry that was granted unfettered access, including having not just the kind of constitutional direction from the House, but also the powers for documents and evidence and ultimately judicial oversight, do you believe that that would be a good, nonpartisan, non-political, unobstructed opportunity for us to deal with these matters of national importance when it comes to piercing the veil of cabinet confidence and the ability to pursue any types of allegations of wrongdoing? Would a public inquiry have provided the remedy that seems to have frustrated you in your ability to have a full investigation?
So, Mr. Chair, I would say that even with the public inquiry, I think cabinet confidence still applies, and that's something that you have to work out, but my understanding. So, again, real short, I think cabinet confidence was set in place for a reason. I'm far from being an expert in that. I think it has to be reviewed as to why it was put in place and the interpretation of cabinet confidence, as I discussed with the Honorable M. Villemur.
In the RCMP assessment report from February 2021, I've identified two items which partially explains the RCMP's reluctance to not continue the investigation. You referenced this as early. JWR, Jody Wilson-Raybould, did not think a crime was committed. She stated the Prime Minister's actions were inappropriate and unethical, but not criminal. Did the fact that she was still a member of Justin Trudeau's cabinet factor in that analysis?
To be honest, Mr. Chair, I'm not exactly sure if this was a factor.
Thank you.
In her determination.
Yet after Dion's report, she told the RCMP that information she read gave her cause for concern. Are you aware of that?
That's correct. Yes, Mr.
Is
Chair.
the RCMP in the habit of outsourcing investigatory decisions to non-investigators?
I'm not exactly sure about the question, Mr. Chair.
You seem to be relying upon the fact that she used the words, "I don't believe Justin Trudeau's actions were criminal." That seemed to be a factor in your analysis. Are you saying that wasn't a factor?
Yes, of course, it was a factor, Mr. Chair.
So the question is very specific. Do you generally outsource a non-police citizen to make that type of an opinion of a legal matter?
You mean from the former Attorney General?
Yes.
I would have to say that her testimony is important in the assessment of the overall situation.
She was a member of the Liberal Party of Canada. Of course she's going to say it's not criminal. She was hanging on to her job. Can't you see that as an issue here? Yeah, I'm pretty sure she was. Right? And she paid for her price because of her refusal to follow Justin Trudeau's lead in offering the DPA. I'll move on. Dion's terms of reference required him to shut down the inquiry if he discovered evidence of a crime being committed. Did that weigh in your decision as well?
Again, I would have to say, Mr. Chair, that this was not a determining factor.
Okay.
Again, it was based on the overall. This is one element amongst a
myriad. The Justice Committee, before it was shut down by the Liberal government, interviewed 5 witnesses. Ethics Commissioner interviewed 14 witnesses, yet you interviewed 4 witnesses. You did not interview the Prime Minister. You didn't interview anyone in his office, the PMO or the PCO. My last question to you is, you had the opportunity to interview Justin Trudeau and you declined, yes or no?
What I have to say, Mr. Chair, that this is an answer that's not a yes or no question. What I have to say is that when we look at this, of course, our purpose is to look for criminality. We need to meet that threshold before we can proceed to further steps. Again,
and everyone else had an interest in those witnesses except the RCMP. Thank you. Moving on to Mr. Cooper.
2 minutes, Mr. Cooper.
Thank you, Mr. Chair. Just to clarify for the record, the RCMP could not rule out criminal wrongdoing on the part of the Prime Minister, correct?
Go ahead. Of course, Mr. Chair, I would have to say that until we had a chance to look at everything.
It's at paragraph 23 of the conclusions and recommendations in the investigation report. So you can confirm that.
That's correct, Mr. Chair.
Okay. And was the RCMP hindered in its investigation when it drew the conclusion that there was insufficient evidence to further pursue the Prime Minister, including because of the refusal of the Prime Minister's personal department, the PCO, to expand the order in council?
So again, Mr. Chair, we worked within the parameters that were given to us and the regs that were given to us, and we did apply.
And the parameters were inadequate.
And we did apply to open through an order of council to have additional information, and it was refused.
It was refused by the PCO. And paragraph 24 of the investigation report states, however, should additional evidence be uncovered corroborating a criminal intent to obstruct justice, it would be recommended that the occurrence be reopened for further investigation. Now, I have a real tough time understanding, in the face of the obstruction that the RCMP was facing by the Prime Minister and the consequent lack of evidence to further pursue getting to the heart of the issue, that being obstruction, why the RCMP didn't see fit to even pick up the phone and contact the Prime Minister and schedule an interview with him.
Quick response, if you will.
Yes, I would have to say, Mr. Chair, in this situation, of course, again, we have to operate within the parameters of what we have. It's not to me.
Nothing within the parameters that you had that would have precluded you from picking up the phone to contact the Prime Minister.